If the print doesn't fit, you must acquit. Thank you.
Okay.
I think it's effective. Takes care of your fingerprint analysis.
At first I thought you said if the print doesn't fit.
Oh,
instead of the
jeez.
print. I was like,
Print, that's the accent.
I don't
All right.
get it.
Ladies and gentlemen of the jury, you have heard a tremendous amount of information, and it becomes very difficult to try and put some sense of order and make sense of it. So I'd like to talk to you about a timeline of the events, and then talk to you about who you did hear from today. Now let's begin. On September 14, 2010, Miller's Fine Jewelers was robbed. Ms. Weikes provided the identification of the suspect as being a man in his 20s, a white man in his 20s, wearing a hat with a star on it, a tan jacket, and dark pants. That's it. Investigation of Miller's Fine Jewelers, where Ms. Nicholson dusted for prints, only turned out three prints, but two latents. Two from inside a safe, and one from a coin recovered outside Pavilions Plaza. The next day, on September 15th, the Press Clarion, Nita City's local newspaper, published an article relating to the events that occurred. However, as you heard testimony, a lot of what was contained was incorrect. And the importance of that becomes a little more important as I get further on. Now mind you, from September 14th to September 21st, there was no evidence linking my client, Ardell Delaney, to the case. The case, for all intents and purposes, has gone cold. And on September 21st, Officer Johnson pulls over Mr. Val Cavaretta for suspected DWI when he failed all three field sobriety tests. And then when he attempted to hide a half a kilo of cocaine in his car and then further deny whose it belonged to, he was subsequently charged with possession with the intent to distribute cocaine. Now, realizing he was facing 10 years in jail as he was already on probation and has a rap sheet, a very extensive rap sheet, the man decided to cop a plea or bargain on his sentence that was forthcoming. And he named my client, Ardell Delaney, as the suspect in the Miller's Fine Jewelers. Now, the police followed up on this and conducted an investigation. And they took Mr. Ardell Delaney's left index finger print from 7 years ago and compared it to those that were lifted from the crime scene. And what did that turn out? Nothing. There were no matches that were made to my client. You heard from Ms. Nicholson, she was unwilling to say that my client, Ardell Delaney's fingerprints were those that were on the coin. We don't know whose fingerprints belong to those in the safe because there was no further investigation done on it. There was no elimination prints of anybody else that even worked in Miller's Fine Jewelers that day. Not satisfied that my client didn't commit this crime, the police investigated further. And they brought my client in for a lineup. And they brought Ms. Weikes in for a lineup. And at the lineup, you heard about all the different flaws and errors that occurred. First, all 6 men in the lineup looked like my client, rather than the description provided by Ms. Weikes. That is a man in his 20s wearing a baseball hat, wearing a hat with a star on it, tan jacket, and dark pants. No one said they were all wearing orange jumpsuits. Nor did any of the suspects speak, despite the fact that Ms. Weikes had explained to Detective Lowry that the suspect in the robbery had asked her to do certain things. You also heard from Pepper Hack, whose testimony was read into trial, that Detective Lowry, and confirmed for that matter by Ms. Weikes, that Detective Lowry said something to her, and something along the lines of hurry up. So what did Ms. Weikes do when she identified suspect number 4? She wrote, "I think it's number 4. Not I know, not I'm sure, not I'm positive. I think." And as you all can see, there is plenty of space on this form for her to explain why she thinks. But she didn't do that. Now, even still, the police continue to pursue my client. And when they arrested him for suspicion of committing that robbery, what did he do? Instead of hiding behind a lawyer he waived all of his rights. He immediately provided an alibi, which was confirmed through the testimony you heard from Mr. Pafko on his whereabouts on September 14th. And he waived his rights to his privacy when he permitted the police, without a warrant, to search his house, or his apartment, and his car. And what did that turn up? There was no gun, no ammo. There was no cocaine, no drugs of any kind, no paraphernalia. None of the currency that was involved in the robbery, no silver dollars. But what did the police take? They took a Houston Astros hat from a guy who plays for the Houston Astros. Now let's talk about the evidence that the prosecution wants you to believe is sufficient enough to carry their burden of proof. You heard from 3 people throughout this entire trial. Miss Wycus. Now, Miss Wycus undoubtedly suffered a traumatic event that none of us hope to have to go through ourselves. And we all feel empathy towards her for having gone through it. But that doesn't change the facts of this case. And nobody's upset with Miss Wycus for her failure and inability to make a proper identification. As she testified, the man's hat covered half of his head. She was ordered to look away from him, ordered to face the ground, and even when she was given the ability to look at him, all she was able to look at was the gun. And she testified she doesn't remember which hand the gun was pointed at her. What is surprising, though, is how her memory as time goes by gets stronger. Whereas we all know from common experience, that doesn't happen. Instead, as time goes on, we all start to forget things. Now, evidence of this occurrence can be seen plainly through the original statement she made to Detective Lowry, to that she made during her preliminary. A man in his 20s went to being a man in his mid-20s. A man with a hat with a star on it went to a Houston Astros hat. A man wearing a tan jacket and dark pants went to being a man wearing a striped shirt and khakis. I think it's number 4, so I'm absolutely positive it's Ardell Delaney. Ladies and gentlemen, it just doesn't make sense. And you heard from Dr. Sheffin all the factors and reasons and scientific evidence that makes it not make sense. And then the prosecution puts in front of you Val Cavaretta. Ladies and gentlemen, Val Cavaretta is a menace. As I said earlier, he has an extensive history with the law. This man knows how to manipulate the system. He knew that if he tried to give up information about an important case to the police, that they would be bending over backwards to make a deal with him. And in fact, they did. They provided him, instead of 10 years, they gave him a get-out-of-jail-free card. So ask yourself, what credibility does Mr. Cavaretta have? I argue none. The man has lied through this case, as well as in the past. He is currently on probation for submitting a false police report. He also lied twice during this case. He said that he had bought the cocaine for $16,000, but quite easily remembered that it was $15,000, just because he wanted to get an extra $1,000 out of his friend, Ardell. A friend that he wasn't willing to be a snitch on, but is willing to send him to jail. And then ask yourselves, finally, why didn't the prosecution put the lead officer on trial in this case? The man who conducted the entire investigation? Well, I believe that it's because the investigation is flawed throughout. Now, you'll recall at the beginning of the trial when I spoke to you about reasonable doubt, and that the prosecution has the burden to prove their entire case beyond a reasonable doubt. Ladies and gentlemen, by now, the evidence that you've heard and all the witnesses that have spoken today, it's clear that this case is riddled with reasonable doubt. And therefore, when you go back into the jury room and you're handed the verdict form, reflect upon that. Reflect upon all the different pieces of doubt that exist in this case. And then fill in the verdict form for my client, Ardell Delaney, as not guilty. Thank you. That was too long.